Good evening, everyone. Hope everyone is safe and healthy. I would like to welcome all the participants to the webinar on the matter of electronic evidence under Indian law. Before we start with the webinar, some hygiene points to be taken care of. I'll just share the slide. So everyone is on mute except for the speakers. We strongly advise all the participants should not uh, open any links or share any links on the chat box. Last 20 to 30 minutes will be spent on Q&A with the panelists. So we recommend all the participants to post questions on the Q&A box, which is there on the bottom panel. The webinar is also being recorded and will be available on our Legacy's YouTube channel. So please subscribe on Legacy's YouTube channel. Moving on.
Mehak?
Yes, everyone can listen.
Yeah, will
Yes, sir.
you flash on the screen? I'll share my screen and
Yes. I'm just stopping the screen.
Sure.
Yeah. Session will be moderated by Mr. Suhas Soljapurkar. He is the founder director of Legacy Services and managing partner of Legacy Partners. Welcome, Mr. Soljapurkar. Uh, I would like to introduce the panelists for the webinar. Uh, Meenakshi Arora. Uh, Welcome, ma'am. Little bit about Meenakshi Arora. She
Mehak,
is, yes, sir.
Mehak, I'll take it over.
You'll take it over. Okay, sir.
Yeah.
Yeah.
Okay. Thank you, Mehak. Thanks a lot, Mehak, and I think a very good evening to everybody. Shubha Sandhya, Namaskar, Namaste. I think on a very important topic, which is really when we're talking about digitization and digital explosion that has happened, and COVID has accelerated this digital explosion. I just want to begin by saying that there are certain caveats as a typical lawyer I would like to mention, which is that this is webinar is for general awareness. It's not a legal advice or opinion. One of the issues that we are talking today is also related to digitization that's arising out of COVID, and we look at the risks arising from COVID differently, and it's a dynamic situation today. This webinar takes an eagle view approach and deals with some of the legal issues arising out of Arjun Khudkar's judgment. I wouldn't say it is an exhaustive. And the views that we are expressing are our personal individual views. They do not reflect the organizational view. With these, some of the kind of caveats, I want to move ahead. Mehak, has there been any, there's an echo, I'm not too sure. Am I audible?
Yes, sir, you are audible.
Okay. So I think our gratitude to the frontliners, the doctors, healthcare experts. We want to kind of say a big thank you to everybody who has supported us during the COVID period and continue to support us. Um, there are various law enforcement officers and police personnel across the country who have actually stood there to make sure that the lockdown is successful and we are all safe. I must say a big thanks to all the police personnel who have ensured our safety. We've also seen there is a lot of positivity that has been maintained in the ecosystem and the environment by various artists. And if you look at this Tambaram station here, which I took a liberty of putting a picture here, is one of our friends' daughter who actually created a mural around an entire Tambaram station has been converted into a gratitude to say that big thank you. So all frontliners, this is we are safe today, and this webinar is dedicated to you all. Just to kind of lay the background before I introduce the panel, um, you see, if you look at the data today, the data never sleeps. And if you just take a brief view of this slide here, I think you will realize the kind of magnanimity of what we are talking when we talk about the matter of evidence in the digital space relating to matter of fact. Matter of fact is a phrase that we use all the time, even in a colloquial way when we talk about it's a matter of fact. But look at it today, the digital space, which is predominantly the internet, has a population of 4.3 billion people at the same time there on the internet. It's an internet nation there, which has a population of 4.3 billion, which is almost about 56.1% of the world's population in this space. You can imagine the kind of data that gets generated here. And this is boundaryless internet here. The second aspect, which is very important, is to say that while we talk about internet, you know, now today, every equipment is talking, every device is talking to another device. So there is Internet of Things. There is artificial intelligence that's come up all across various devices, and IoT is actually creating various challenges from legal perspective as well. Fundamentally, we all understand that whenever we talk about legal issues, and especially in relation to the evidence, we always talk about beyond reasonable doubt, and preponderance of probability comes in there as a second alternative, if I were to put it in some jurisdictions. But this entire data is very volatile. And I think that volatility of data is such that in certain devices, it just visits in a nanosecond, that data gets erased or moves out from that device. So when we talk about the source of device, we talk about computer devices, we talk about computer systems and network, which is part of the definition that we have today. But gathering evidence from internet with various challenges such as IoT, such as mashup of evidence, all of this kind of creates a phenomenal challenge. Then you have stagnography, then you have deep web and dark net. I think with all this that is kind of visiting us virtually, every minute of the day, this data gets generated. We have an extremely interesting panel, and I think I'm going to kind of uh, go one by one here. We have Apurva Sardeshmukh, who is a partner with Legasis Partners. He's a lawyer with almost about 13 years of experience today. He has been handling um, various IT related issues. Very interestingly, he is author of Thomson Reuters Publisher book on data privacy and data regulations. Welcome, Apurva, and thanks for joining this panel. We have Ms. Basuri Swarajji. Basuri, thanks for joining us here. Basuri is barrister. She's bar at law. She's almost about 15 years of experience today. She she is practicing in Supreme Court, and she is one of the budding lawyers of India, if I were to put it that way. She also kind of serves as the AG for State of Haryana, additional AG for State of Haryana, pardon me. Thank you very much, Basuri. Thanks for joining us. Welcome on this panel. Uh, then we have Mr. Vinodji Trivedi, Tiwari ji. Sorry, my apologies, sir. Vinodji has been a lawyer for more than about 34, 35 years practicing, and a distinguished engineer and a lawyer, a very rare combination today. And sir, in the Internet of Things, in the internet technologies, I think we need people like you to guide us. Uh, is also judicial member on Water Regulatory Authority of Maharashtra. Thank you very much, sir, for joining us today, and welcome to this webinar. We have Mr. Ramesh Sharma. Ramesh Sharma brings in a very interesting perspective from law enforcement agencies. He's been DG Economic Offences Wing with Madhya Pradesh, more than about 37 years in the field. Actually, out of that, almost about 20 years in a highest echelons of in India, and that's kind of with empirical evidence. That book is a guide for many of us. Thank you very much for joining. Good evening and welcome, sir. And finally, I think as a crescendo, I would say we have Meenakshi Ji Arora. Madam, thank you very much for gracing this occasion and joining us. Very warm welcome this evening to you. Uh, it's it's my honor, and as Ramesh ji said, it's our honor that you are amongst us here today. It's very um, your very presence kind of gives credence to the fact that this issue has to be brought to the forefront as an awareness and knowledge generating session across India today. And from that perspective, madam, just to introduce you, and I don't think you need introduction amongst us as lawyers, definitely no. But to kind of just kind of put the things in right perspective, you've been one of the first 5 women senior advocates of India, and that's a great credit. Thank you very much for being there for us. You participate in various judgments that have set the course of the law, and this is one such judgment where we look forward to hearing from you. Without wasting too much of time, I think, ma'am, I'm going to request you to give your overview. How did you fight this matter? How did you win this matter? More importantly, what is on take for us as budding lawyers? Madam, you're on mute. You're on mute.
I'll just.
Hello?
Ma'am, you are on mute. Yeah.
Now it's fine.
Yeah, I'm sorry. Now, first of all, Suhas, thank you for very, very kind words. You make me more nervous when you speak so many kind words, actually. So your expectations become much higher. Anyway, so I will, without any ado, having been here, clearly jump into the issue that we have before us today, and that's the judgment in Arjun Pandit Rao Kotkar, now pronounced by the Supreme Court. So what I decided that to give an overview of what really had transpired in arriving at this judgment, and secondly, what will be my endeavor this evening and the briefest shortable time so that everybody else has this opportunity to come out, is to what has the court finally held, is to just sum it up as briefly as I can. So the background is, as we all know, that when Section 65B was introduced into the Evidence Act, the Supreme Court had two conflicting views that came up before the Supreme Court. One was P.V. Anwar view, which said that Section 65B, for the purpose of introducing any kind of an electronic evidence, was a complete code by itself, had to be strictly followed, a certificate required to be given. That certificate would be the entry point, or let us say, cross the goalpost first for producing any kind of an electronic evidence before the court. It had just one paragraph in P.V. Anwar, which was paragraph 24. And Anwar came out of an election judgment where a video had been used for the purpose of making certain statements to the public, which was found to be an offending article. And the court said, if that original video cassette had been produced and not a copy thereof, then perhaps we may not have required this 65B procedure. Now saying produce that original VCD which was there. So that would have become a primary evidence. Later on, over a period of time, came a set of judgments, the last one being Shafi Muhammad, but before that, a judgment of Tommaso Bruno, and some part of it in Ajmal Kasab, Navjot Sadhu. They all were of the view that you can't make a procedural law a complete code by itself. So if suppose a party is unable to get a certificate as is required under Section 65B of the Evidence Act, are you going to leave all that evidence to the mercy, not take it into consideration? It's an important, valuable piece of evidence. So they came, particularly Shafi Muhammad, said that you can use the secondary evidence route and you can prove it. So if you have not got a certificate on record, take the route of secondary evidence and prove it before the court in the form of a secondary evidence. Significantly here, Anwar was a 3-judge bench, Shafi Mohammed was a division bench of the Supreme Court, but Tommaso Bruno, which had one judge who was common with Anwar PV, Justice Kurian Joseph, I think, was also a 3-judge bench judgment. Now, what happened in Kotkar, really, to take us to the reference? Kotkar was again an election matter. It was a case of receipt of nomination papers before the court, an election petition. The whole issue was that the nomination form had been improperly accepted by the returning officer. And the issue was before the returning officer that the nomination forms had been accepted after the time where they can be presented was over. And the best evidence in that is because at the time when nomination forms are accepted by a returning officer, everything is video recorded. It is compulsory for a returning officer to have a video cameras both outside their offices and within their offices to ensure the timing of acceptance of these nomination forms. Therefore, these recordings of the video in the office of the returning officer became significant piece of evidence. Now, what happens is the closure happens at 3 p.m. At 3 p.m., an officer from a returning officer's office comes out and says, all of you who are present right now at 3 p.m. and in a line here in the office, your forms will be accepted, but anyone who's not present here cannot be accepted. This gentleman, Kotkar, he wasn't present in that queue, which is a video outside the office of the returning officer. He's not present there, neither does he give his name to the person who comes out. But he submits his forms to the returning officer, and at that time, the video recording inside the returning officer's cabin shows, and which the videographer has to take, that the clock on the wall shows it's past 5 p.m., which is much after 3 p.m., which is the closure time. So this became a hotbed of contest before the High Court in the election petition. Our client, who was Kailash Gontrial, filed the petition, said his form has been, because he was a return candidate now, Arjun Pandit Rao Kotkar, he challenged his election and said his forms have been improperly accepted. He asked the Election Commission, please give me the video recording of what transpired on the day his form was accepted. The Election Commission gave the video recording as its obligation to the election petitioner. Election petitioner asked for a certificate under 65B from the Election Commission. Not the commission, the returning officer's office. That certificate was not forthcoming. However, also before the High Court, once again, the election petitioner sought the High Court to give a direction to the returning officer to give this particular certificate. The returning officer did not give the certificate under 65B. Now, why I'm saying this, because it will have some relevance when I discuss the judgment shortly. The advocates were very sharp and very bright. They asked for the returning officer's presence as a witness in the witness box. They cross-examined her extensively. And in that cross-examination, they put to her all the questions that you could have in a Section 65B certificate. So they kind of discharged their obligations of a 65B certificate indirectly and brought about her evidence and the evidence of the assistant officer present there. So the High Court eventually held, looking at all the material, including other material on record, he said the returning officer was asked time and again to give a certificate. It is not within the power of the election petitioner to give that certificate. It has to come from returning officer in whose possession the video camera, recording, etc. has been maintained. She has consistently failed. But her evidence is a substantive evidence to prove this particular video recording. So the High Court, apart from the other evidence, relied upon this video recording to arrive at a conclusion that it was an improper acceptance of a nomination form and set aside the election of Arjun Pandit Rao Kotkar. Matter was carried to Supreme Court. The very first contention that was raised before the bench was that this evidence cannot be entertained because it is not accompanied by a Section 65B certificate, which is required in view of Anwar PV judgment. So this issue between Anwar PV and Shafi Mohammed came up before the division bench of Supreme Court, and the division bench said, well, because Anwar PV and Tommaso Bruno are three-judge bench judgments, and Shafi Mohammed being the division bench, they found it appropriate to make a reference. And this is the decision on that particular reference by the Supreme Court here. I have, just to be brief and quickly take you through, summarize the answer that has been given by the Supreme Court to the reference in about 11 points that the judgment effectively decides. And quickly, briefly, and as succinctly as possible, I will take you through these 11 points very, very shortly. First of all, the Supreme Court in its reference holds that 65B, subsection 4, which says that a certificate is actually uses the word or. That means you can, the information produced, you can give an information which is produced by the computer during the period it was used regularly to store the information, or the information was regularly fed in, computer was operating. You know, it says that subsection 4, which has to satisfy the test of 65B2, you have to write all of them. So the word is not or, but it is and certificate must be in respect of each of the contents of 65B2. So it is not now or, but it has to give in respect of all of them. Number one. This certificate has to be given by a person who's a responsible officer, and to the best of knowledge. The word that is used in subsection 4 of 65B is and. So the Supreme Court corrects it, and this is a very minor one, and said, no, the word cannot be and, because if you say it is knowledge and belief, that's not correct. It will be knowledge, best of my knowledge or my belief. So a person who's occupying a responsible position, who has some kind of management control over the device, can give this particular certificate, etc. But this is not where the judgment really ends, because it takes it further. The Supreme Court goes and says, Section 62 to 65, which is primary evidence, secondary evidence, are irrelevant for the purpose of the drill of Section 65B. It also goes on to hold that the difference between an original information contained on the computer itself and the copies made therefrom, whereas the original information on a computer, now this is very important because it will take you to the next stage, the original information which will be contained on the computer itself will be the primary evidence. And any copy that you would make therefrom will become a secondary piece of evidence. Now, then the Supreme Court says that under Section 65B4, if the original document is itself produced, that means if the owner of a computer steps into the witness box, proves himself as an owner of a laptop, a computer tablet, or a mobile phone, then this particular entire thing becomes a primary evidence. It will not require any certification under 65B4 anymore. This is original, it is owned, operated, it has been proved, and therefore that is where it ends. No requirement of 65B4. But however, if you have a computer which is a part of a computing network or a computer system, and it's physically impossible to bring that computer into the courtroom when you're stepping into the witness box, then the drill under 65B is required to be followed. So therefore, primary evidence, which was discussed in paragraph 24 of Anwar, was clarified in this particular manner, in this particular judgment, and that's an information for anyone that who will use it. If you have a tablet, or if you have a small laptop or a mobile phone where it is contained, step into the witness box, show that particular part of it, and you are home. You don't have to do anything more. But however, if you can't take it, then you have to go in with the drill of 65B4. Then it says that the law which was declared in Thomson Bruno, that 65A and 65B, it is not a complete code, and because it is only procedural, it can be relaxed, is not a good law at all. So they said there is a strict mandate. They say that it is per incuriam the judgment, and therefore Thomson Bruno is being per incuriam. To say that it's only merely procedural, it's not a good law. Shafi Muhammad, they categorically hold that it's been incorrectly decided. But then, what follows from the judgment? So what do we do now? The Supreme Court says that if you are unable to get a certificate, for example, as quote here, Gontral was not able to get a certificate, or if you are a person who has a document, but the computer or the methods, means are not within your power to obtain a certificate, what would you do in that event? There the Supreme Court says, follow the process as is contained under Section 165 of the Indian Evidence Act, Section 6 and 7 of the CPC, and 91 of CRPC. Now, what are they? 165 Evidence Act, where a judge can order a production of a document, or he can order the presence, summon the presence of a person who can produce. So the Supreme Court then gives you a pointer that you are not able to do it, you are not able to prove it, follow the route of Section 165 of the Evidence Act, get your judge to summon the person who can give it or order its production. In a civil matter, there is similar provision under Section 6 and 7 of CPC. Summons to produce a requirement require the person to give an evidence. CRPC, now here we are going to have a little bit issue on what the court has decided and what is, if I may say, my view about it, if I may just add that a little bit. 91 CRPC is again a production for summoning. The Supreme Court goes on to add a small caveat here, so far as the matter in hand is concerned, which is Arjun Kotkar's appeal. Here the court says then, a party did everything which was within its control. Asked the authority, required the court ordered, but yet the certificate was not coming. Now this may be a pointer for future for the parties to act on. Says, but authority willfully refused on some pretext or the other. Therefore, in these circumstances, the party can apply to the court for its production and follow the provisions. And then it says that the law does not expect you to do what is impossible. Lex non cogit ad impossiblia. First Latin maxim the court applies, and the court applies these two Latin maxims very seriously in arriving at its conclusion. And then he says, impotentia exuset legem, which is where there is a disability that makes it impossible for you to obey the law, then the alleged disobedience is excused. Now, if in these circumstances you are unable to produce a certificate, the law will not ask you to do the impossible, you will be excused from its performance, and therefore the court can proceed on the basis of that particular evidence and take. But the circumstances, the court will follow the process of Section 165 of the Evidence Act. It will follow the process of 6 and 7 of the CPC or 91 of CRPC. So the court says that while we hold 65B is mandatory, but because Kailash Gontral had done whatever was possible within his means, he could not produce a certificate which was within the control of a third party. So he is now relieved of its mandatory obligation to produce such a certificate. But the other point that court holds, and which is very important, is he says, at what stage will such a certificate be produced? Now, this is another important facet of a decision in the present case. Let us remember, in PV Anwar, the Supreme Court had said that a certificate has to be produced when an evidence is produced before the court. So right at the initial stage, when you produce the evidence, you give the certificate. Otherwise, you don't cross your check post. You don't cross the goalpost on admissibility. The Supreme Court relaxed this particular position or explained it by saying that where the production of certificate is within your power and control, you will give the certificate when you produce that particular evidence. Assuming I have the computer, I have everything, all wherewithal, I can produce it, I will give it right initially. But if the certificate is for some reason defective, or where it has been demanded and it has not been given, then now comes the next limb of its discussion. The judge who's conducting the trial will then summon the person and require the person to give a certificate. And the judge must do this when electronic record is produced without the required certificate, but some amount of discretion may be with the judge. But when it comes to criminal trials, the court puts in a caveat. The court says that in a criminal trial, ordinarily, all your evidence is produced at the time of filing of a charge sheet. And that's a benefit that an accused has because it's filed with the charge sheet. The rights of an accused have to be protected. So therefore, if in a criminal trial, a certificate is being given at a later stage, it is the rights of an accused have to be balanced. And there it's recommended that you would then follow Section 91 or 311 of CRPC, where you would have a right to recall a witness, and the witness can be recalled and cross-examined again, so that, or you can follow the route of, again, 165 Indian Evidence Act, namely that you will require the court's witness to be summoned, and therefore there's a right to cross-examine. So that's a balancing of the rights of an accused. Now, I have a little problem with this particular one because we give a lot of weightage to protection of a right of an accused. There is a right of a victim in every criminal trial. And we need to someday discuss that. And the caveat that I'm adding here, and I'll just take a few more minutes, there's not much more to be said in that, just a few more points. But the caveat that I would add here is, you know, very often the victim or a complainant is not a person of means. They are not fairly nuanced, or they are not familiar with the provisions of CRPC, Indian Evidence Act. And number two, in a criminal trial, the complainant has no role to play, a victim, because it's a matter between a prosecutor and then the state. And normally, the victim virtually stands behind the public prosecutor and can only watch what is happening. Assuming that a prosecutor is not aware or chooses not to put this valuable certificate on record, together with the electronic evidence that is there, where do we leave the victim here? It is only something that a prosecutor can do. And if he chooses not to do, and my judge is not proactive, we could sometimes miss out a valuable piece of evidence. So I think we may balance the right of accused, yes, very well. But something we must now start to look at the rights of the victims, the complainants also, was my feeling in this whole process. Now, the other thing that court goes on to say is, and that is now in view of this declaration of law by the Supreme Court, that so long as the hearing in the trials is not over today, whichever is pending, electronic evidence is a part of that, requisite certificate can be produced at any stage, because it's now a declaration of law, reconciling the views, so you can produce a certificate at any stage. But there are a lot of matters which may be at an appeal or stage. There is no declaration so far as that is concerned. So I guess Supreme Court says whatever is done is done. perhaps, but if you are still at a stage of trial, you can do it. Now, so far as who is a person who will certify it, the Supreme Court gives an explanation very clearly. He says certification can be done by anyone occupying an official, responsible official position in relation to operation of a relevant device or management of the device. And again, certificate to be the best of the knowledge or belief and not and belief. Therefore, today, Section 65B4 certificate is a condition precedent virtually in the matters of electronic evidence. Now, the court also proceeds to give a general direction to all cellular companies and the internet service providers to maintain their CDRs in a segregated and a secure manner if these CDRs or records have been seized in matters of any investigation, so that they can be summoned by the court in the criminal trials. But this direction is vis-a-vis the criminal trials. Finally, upholding Anwar is a good law, Tommaso is per incuriam, Shafi is an incorrect declaration, certificate is not required if original is produced or can be produced, like your laptop, your tablet, or your mobile phone. But if you can't, and you are a part of a network, 65B becomes a precondition. The general directions which are given in this judgment, which is with respect to trials, which is Section 165 of Evidence Act, CPC, CRPC to be followed henceforth, and rules under Section 65C of the IT Act to be framed, and which I'm sure many others after me are going to throw a light on. I am not familiar so much with that. I'm not even going to venture out into that. And so far as retention of data is concerned, ending it there, the judge does feel that there is a need for amendment of the rules under 67C of the IT Act. But what Justice Rama Subramaniam, who writes his own view, this was a 3-judge, but Justice Rama Subramaniam supports the view of Justice Nariman, but traces the development of law with respect to production of electronic evidence in at least 3 jurisdictions, USA, UK, and Canada. He has a very interesting observation to make. He says, we adopted Section 65B and more particularly 4 in the year 2000, when UK had already repealed its, because it's pari materia to the provision that UK had earlier. We took it from there, we borrowed it from there, but by the time we adopted it, they had already moved on and amended their law. And they had amended their law to a stage where they said that in matters of electronic evidence like this, hearsay admissible evidence is the test. So therefore, there can be self-certification, and it would be in the category of hearsay admissible evidence. And therefore, Justice Rama Subramaniam goes to say, there is an amendment which is required. He agrees with the Justice Nariman's opinion, but he says there is an amendment to be needed. And I'm surprised that Suhas didn't use that particular code, but Justice Rama Subramaniam says that the judicial swing of the pendulum, and as Suhas said, and I'm only borrowing it from you, has today stopped with the present judgment in Kotkar. So that's plagiarism of Suhas' line. But the judicial swing of the pendulum comes to a halt, at least for the moment. And I do hope that the amendments, as are envisaged by Justice Rama Subramaniam, do follow soon enough in this. I hope I have not taken too long and have left enough time for the others to speak on this. Thank you so very much.
Thank you very much. In fact, I had kept this and reserved that quote after your speech. No.
I read that in Justice Rama Subramaniam's quote, but it is correct, not complete as you said it. You said it much better.
No. And I must quote him. He says, with the law swinging from one extreme to another.
Absolutely.
In past 15 years.
Yes.
From Navjot Sidhu to Anwar
Yeah.
P to Bruno
To
to
Shafi.
Sonu to Shafi.
To Shafi in 2018.
Yeah,
Yes.
and there is a huge judicial turmoil
Yes.
because of this. And madam, thank you very much for stopping that pendulum. You know, because very broadly, I think if we forget Navjot Sidhu, which was 2005, but Anwar, which is 2014, to Shafi, which is 2018, and you've been instrumental in making sure that Arjun Kopkar stops this. Okay, thank you very much. Madam, you raised a very, very pertinent question about right of the complainant, especially when we talk about the digital space and electronic evidence. And therefore, I'm going to move to Mr. Ramesh Sharma. And Ramesh ji, you've been part of the investigations and enforcement for a long, long time in this space. You see, although balancing both between the right of the complainant um, and the right of the offender, if I were to put it that way, uh, you know, that balancing is required. But what Minakshi Madam made a point is, we should also now talk about right of the complainant, not merely balancing everything on behalf of and for the accused. Sir, your views, overview on the judgment and practical aspect of it, plus a specific issue about right of the complainant.
Sir,
Sorry,
you are
sir,
on
you are
mute.
on mute.
Sorry, am I audible?
Yeah, now,
Yes,
now.
sir.
Thank you.
Sorry, I was on mute. So I was saying that as soon as an FIR is registered, the entire purpose of investigating agency is neither pro-complainant nor pro-accused. The whole idea is to find the facts of the matter. And therefore, complainant is only the beginning point where certain offenses are brought to the notice of the investigating officer. And an investigating officer is expected to be fair and just in collecting evidence, which may result in filing of the case, FR as we call it, finally reporting of the case because of lack of evidence, or charge sheeting the case. So therefore, the rights of the complainant are very much, in fact, this is what the law is, or this is what the practice is. But by and large, one sees that the investigating agencies do tend to actually, move more in favor of the complainant rather than the accused. That also is a fact. Having said that, as far as the police officers are concerned who are part of this group, I would like to remind them, aside from the judgment that has so wonderfully explained by Madam, we have to be very careful as far as the collection, seizure, and registration of the electronic evidence. I thought I should certainly highlight this point, especially when it comes to electronic evidence. I'm sure the police officers are aware of it. They have been sensitized that how to unplug the entire computer, not switch it off, not switch on the computer, how to put the void, what you call, the laptops or the mobile phones into non-static bags, because now even remotely, the hard disk can be, mischief can be played with. So to putting it in a non-static bag is very, very important. So the whole process that we followed in CRPC as far as the seizure of various evidence is concerned is actually the same procedure that has to be followed as far as electronic evidence is concerned. That is to say that it should not give at any point of time any perception or impression or evidence that the evidence has been tampered with. And that is why the taking of the screenshot of the computer when in the state as it is been found, or not switching on the computer, not touching the keyboards of the computer, etc., have to be followed with. And also the chain of command has to be maintained, proper seizure memos, etc., has to be prepared. So this I'm sure my fellow brethren are aware of. If not, I mean, that is the important part, because then only after that the matter goes to the court, and the first thing that a defense lawyer does is to find fault in seizures. and find and fault in where that evidence has been tampered with. So this is a very, very important point, which may not directly be related to the judgment that we are discussing with. Coming to the judgment part, madam, I have a few observations of my own. And having been a police officer, obviously many a time we receive information either through a whistleblower or through an informer, as we call it, or as we call it in the intelligence agencies, the source. These are very important people to us, and the general practice is that we protect them like gods. Their protection is most important, that they should not be exposed. Now, in a case like this, where a CD has been, for example, produced by a whistleblower, what happens? Where do we get the certificate from the owner of the machine from which the CD has been produced? That is question number one. Question number two is that the accused would be well within its right to refuse to give that certificate, claiming defense under Article 23 of the Constitution of right against self-incrimination. So I read the judgment two, three times, but I didn't find anything that has to do with this part of the problems that investigating agencies have. I know, for example, in US FCPA, the informers are not at all disclosed, and whether in India a whistleblower and informer would have to be called in the court of law to give any evidence. So these are the 2 points that I thought I would like to have a response to and have a discussion around. And third point, most importantly, is today that when Evidence Act talks about primary evidence and secondary evidence, the primary evidence actually resides in a binary format, which is ones and zeros. So, the judgment, to my mind, has perhaps not taken into account the technicalities of the entire electronic evidence or electronic data that is stored. And today, with the malwares and bugs and things like that, even hard disk can be corrupted, and what is known as the computer output, as defined in 65B, can also be corrupted. And therefore, these aspects also would have to be taken into account while discussing such an issue, and whether the binary data would be the primary data, and what would be then the primary evidence, and what would be the secondary evidence. Thank you very much.
No, thank you very much, sir. Thanks a lot. I think a couple of points that you made where I would like to mention are typically characteristics of electronic evidence. The electronic evidence, I think the presumption is that it's invisible to untrained eye. One, it's highly volatile. As I said, it resides in some devices for a nanosecond. The electronic evidence could be altered, destroyed just through normal use. It can be copied without any degradation. And therefore, admissibility of electronic evidence from the point of view of authenticity, completeness, reliability, believability, proportionality in terms of gathering of the evidence, that is to say its probative value, all become very, very critical and become slightly different from the traditional way in which you would look at physical evidence. See, one of the very critical aspects today is that, who owns or who operates and manages a device. And madam, you allude to that to say that who can give certificate, who is the person who is responsible for operation and management of that device. There is a person who is owner of that device. And if you look at, my modem today, modem that has been affixed in my house, through which I am kind of communicating currently, that modem is owned by Huawei. Huawei continues to own the modem. Now, who owns the data? I'm not too sure. Am I generating data? Probably at some position, at some level, yes. And therefore, you see, all the intermediaries also become very, very critical insofar as the devices and the data movement is concerned. I'm going to request Apurva, with his knowledge in terms of intermediaries and intermediaries regulation, what the judgment intends to do is to call upon intermediaries to preserve the data. Now, there is no concept of litigation hold in India, but to say that how much do I preserve? I have obligation to preserve for 60 days or 90 days, depending on who I am as an intermediary. But Apurva, I just want to pick your brains around this issue to say that, what does Huawei do in kind of a modem situation is as an intermediary? What does my data provider do? Or what do I do if I'm an intermediary today? I'm just facilitating this webinar. Please, Apur.
Yeah, hi. Thanks, Suhas. Good evening to everyone. I think it's an interesting sort of point that you've raised. And while, the judgment, as Meenakshi ma'am very, beautifully explained, is from a jurisprudence perspective, as you has said and Mr. Sharma has said, the pendulum stops and at least there is clarity. As you rightly said, there are a couple of issues that need to be addressed. And I think Meenakshi ma'am did mention this, that during the course of the judgment, the Honorable Supreme Court has now clarified that a certificate under 65B can be produced at any point of time. There is no requirement to actually produce it at one particular period of time, which, I think the Anwar case sort of touched upon, or some other judgment. But this sort of opens another Pandora's box, because as you rightly said, under the intermediary guidelines, currently intermediaries definition is very wide enough. It includes anybody who processes or stores information, who sort of, whose devices are used, as the example that you've given, for transfer of information, are required to store information for a period of 90 days. There is an amendment to these guidelines. There's draft guidelines that the Department of Telecommunications have issued that may come into effect at any point of time now, which talks about a period of 180 days. The agreements that for the license of internet use that the Department of Telecommunication enters with internet service providers provides that they are required to store information for a period of 1 year. Now, while all of us are aware that litigations, trials in India actually sort of go beyond the periods that we've just spoken about, whether it's 90 days, 180 days, or 1 year. Now, in a scenario where, as per a law or as per a regulation, I'm required to store it for a particular period of time, I'm fully entitled to then destroy the information after that time period expires. Now, let's say a trial or any sort of legal dispute goes on for beyond a period. Let's say the maximum period that I spoke about was 1 year, and then a certificate is issued from an intermediary or an internet service provider, or asked for, or information is asked for from these entities. Within the existing legal framework, they're fully entitled to turn around and say that, look, I was supposed to store it for a particular period of time, and I no longer have that information. So while from a jurisprudence perspective and a justice perspective, it is perhaps commendable to say that a certificate can be issued at a period of time, I think we need to then look at the allied regulations in terms of storing of data, retention of information, and the time periods that are sort of that are sort of connected with these regulations, to sort of see how we can then make the judgment and these regulations sort of on the same sort of wavelength or platform, so as to speak. In the judgment, the honorable judges have sort of touched upon the fact that there needs to be regulations to sort of segregate information with respect to a trial or a dispute and protect it. But as an intermediary, as an internet service provider, today I'm not going to perhaps realize that this matter may be required in a year's time period, from 1 year from now, for a particular litigation for a dispute. Hence, it is you really cannot segregate and say certain information can be stored beyond beyond the time period specified in these regulations. We perhaps need an overhaul of these regulations in terms of record retention in view of this judgment. Couple of points that I'll also quickly touch upon, and I think again this was brought about previously in the discussion, in the fact that the judgment says that if information from the original holder of the device is provided, then 65B certificate is not required. Now, who is the original sort of device holder? I mean, in terms of the existing case that we are discussing, where a CD is there, or some sort of a visual sort of record, you can perhaps talk about the original holder. But today, information technology has moved, really miles from where we were. Documents are stored on servers. Documents are transferred from one system to another. who then becomes the original holder is if I download a document from a commonly held server, which may not even be located in this country, it might be stored on what is called cloud. It might be stored outside India, as most IT companies do. Who then becomes an original, holder of information? And finally, I think as alluded in the judgment, we touched upon the UK Act, and Meenakshi ma'am pointed out that the UK regulation was repealed a long time back, and it's interesting to see the comments of the subsisting regulation that came in the United Kingdom, or also refer as it has been done in the judgment to the Canada regulations. I think the presumption there is that, look, if an electronic information is provided, the presumption is that it is not tampered with. Unless there is a question asked with respect to the originality of the document or to the authenticity of the document, the presumption is that it's a valid document. We moved way ahead in terms of information technology and information to sort of say that, look, you need to produce a certificate. I think unless the validity of a certain information is challenged, jurisprudence and jurisdictions all over the world are now moving to a point that we'll consider this to be valid. And if it is questioned, then we will, the burden of proof will be on the party submitting the document. And again, there's no set rule in how to authenticate the document, but then the burden of proof will sort of shift on to the person producing the document. We probably need to look at these aspects as well. When in terms of the judgment, and look at the other allied factors around production of electronic evidence as well.
Thank you very much, Apurva. I think very clearly what you said, I just kind of recalled, when the electronic filing started happening in the high courts, I think I remember the High Court registrar calling us to say that, why can't you give us a floppy? Then they came back and said, why can't you give us a CD of what you have filed in the court? Then they came back and said, why can't you give us your USB drive? So we actually used to give the thumb drive and take it back. So I think who owns that data, who is copying it when the judgment is being written, or some portion of it being copy pasted into the judgment is virtually impossible to kind of decipher that chain there. Very interestingly, one other case is where I think I recall, and I won't take the client's name, SEBI wrote to a client to say that, please give me your all the email data of your employees, including your managing director, CEO, and the directors. We are investigating so and so period, which is from the insider trading perspective. Allegations were made that your people have actually traded during that period. The company wrote back to say that we have no policy of retaining emails beyond 4 days. And therefore, I think they said it's impossible for us to retrieve those mails, and it's impossible for us to give you any evidence. So on the impossibility of doing things, I mean, where the judgment talks about 2 Latin magazines, and there are various impossibilities that would be thrown open, which is norm of the day when you talk about corporate sectors, to say that we need this part as evidence. I think the first thing that comes to anybody's mind is, sorry, we can't give it to you because it's impossible for us to give you this part of the evidence or this document or this information. I'm going to request Basuri on these 2 Latin kind of phrases which have been used, and they're very critical and important. Madam, you kind of told us initially that there are probably pivotal phrases within the judgment there. Basuri, may I request you for your views, and how do you read them?
Thank you very much, Suhasa. And you're absolutely right. A formidable lawyer like Meenakshi Arora has already spoken about the Latin maxims and mentioned them. What would a puny person like me carry on? But I will try and attempt. Now, as far as the impossibility aspect is concerned, I think it needs to be contextualized in 2 manners. So first, let me draw on what my previous speakers have already spoken about. I agree with Apurv completely that we need ancillary legislation to actually make sure that it takes care of all these lacunas and ambiguities that exist. In fact, Suhasa, you began the webinar by saying that data today in itself is an uncontrollable monster. You know, so in my view, what the way the judgment works is that it's perhaps trying to balance out in a very precarious and tenuous manner until the legislature actually steps in and comes up with the laws required to remove this ambiguity. Now, at the risk of oversimplification, as you know, that 65B subsection 4 requires that there is a obligation to produce the certificate. Certificate is nothing but to say that it's basically something on oath, like an affidavit, to say that whatever I'm producing in court is authentic. I know that Ramesh sir was raising very pertinent points about data now being tampered even remotely. But sir, I think from a layman's perspective, I think what evidence needs to be seen as something is tangible and intangible. And electronic evidence is a form of intangible evidence. So what is the way for court to ensure that whatever is being produced before it is authentic and genuine? I understand that the original format of the evidence may be in binary code, but a lay person will not really understand that. So from a legal perspective, it comes down to the ownership of the device, etc. Now, if you actually see the two maxims that you have raised, permit me to just repeat them. The first one is lex non cogit ad impossibilia, which means that the law does not demand the impossible. And the second one is impotential exuviat legem, which means when there is a disability that makes it impossible to obey the law, the alleged disobedience is excused. Now, to contextualize these two maxims, the requirement of 65B4, sometimes the individual may not be does not have access to the device, or he or she may be hindered and prevented from actually accessing the data. In such a scenario, he or she is unable to produce the certificate. This particular judgment, as I said, creates to fulfill that lacuna, especially in paragraph 54 and 55 of the judgment, where it shifts the onus on the court and it puts the obligation on the trial court judge to bring forth or demand that certificate. Now, there is a judgment of state versus, of Sonu versus state of Haryana, which, if you permit me to bring the citation, is 2017 8 SEC 570. This particular judgment says that it basically says that pleas regarding admissibility of e-records on grounds of non-production of the certificate, if it has not been entertained before the trial court, then an objection has not been taken before the trial court, then at appellate jurisdiction, you cannot raise it. The moment this particular judgment, the Kotkar judgment, removes the onus from the individual and places it on the judicial officer, the trial court judge, in ensuring that the certificate has produced, in my opinion, it actually takes care of this ambiguity as well. Now, it does not become impossible to raise this at appellate jurisdiction. I know that many people have a contrarian view on this and see it as a lacuna. I would be audacious enough to take a slightly different view on this. But I believe that until and unless the legislature does its job and comes in with well thought of, well considered laws to take care of this particular ambiguity, this judgment tries to sort of cover the impossibility by saying, all right, let's remove the responsibility from the individual and let's put it on the judge, because if something an individual can't do, perhaps the court can do it.
Thank you very much. Thanks a lot, Vasavi. I'm going to request Vinodji. Vinodji, I think as an engineer and a lawyer, you see, very, very peculiarly today, this space would actually require a lot of experts when we're talking of a new legislation coming out. This judgment, the kind of Arjun Kotkar judgment today, has at one level stopped the pendulum. At other level, there are critics who are saying that the Supreme Court ought to have done much better than what it has done. in terms of merely stopping this pendulum. Sir, I want your views, especially when we look at the future. Where do you see this space going? Because if you ask me, today, my laptop is kind of connected to at least about 20 devices as we speak through wireless. And while person to person, there is this data traffic that I mentioned, but equipment to equipment, device to device, the traffic is going to be multifold. Will the law ever keep pace with the technology? Sir, your views on the judgment and specifically on this issue.
Thank you. Suhas ji, first of all, I must congratulate Meenakshi ji for having this issue resolved to some extent as far as the 65B4 is concerned. But I will go to the next stage where Ramaswamy has touched, Rama Subramaniam has touched the aspects. 2000 to 2020, the 20 years down the line, the entire IT world has changed. Now there is no data in our own hand. Apurva has already told, there are the clouds, there are the servers, which are the original source. If I treat under 65B4, then the certificate has to be, the requirement of the certificate has to be revisited. The court has gone to the extent of the law available and tried to remove certain ambiguities. But the vision of the court is to the extent that mobile phone, computer, or the source, they have not anticipated the situation where the data is stored under the cloud or the servers not in India. So the best course available will be to revisit the law, revisit the provisions of the act. Since 20 years has gone, entire concept of RT has changed now. Incidentally, the Union of India is having Minister of Communication who is a lawyer. MOS is also engineer and the advocate. So I have spoken to them also. This is the best time available to revisit the law. Revisit the law to the extent of the IT Act, revisit the law to the extent of the Evidence Act. While amending the Evidence Act in 2002, we have already have a provision of 45A, which speaks about the expert in the electronic evidence as per the 79A of the IT Act. So whenever there is a challenge to the evidence, so let it be examined under 45A. So there is no need to have any certificate from anybody, and the provision under this 65B4 or B1, B2, B4, B5. If you read B5, B5 is such a stringent, so it's very much complicated. Now, if I read this judgment, this will lead to the derailment of the trials in lower level. Since entire onus is on what? Entire onus has been put on the judge. Wherever there is impossibility, the onus is on judge now. So it will harm the trials. So entire law need to be amended. Unless law is amended by understanding the entire need of the IT now, the entire mess will be continued.
Thank you.
Thank you.
Thank you very much, sir. Thanks a lot. You see, I think it has been very interesting till now, and I wish we could kind of continue. But the interest in this topic is so high that we've been receiving, and there are questions which are pouring. You can actually count at least about 20 questions that have come up. See, I'm going to request Mehak. We will take the questions and answers, and then we will move on, if time permits, to a couple of other issues that are bothering us, at least bothering me, and I would need some clarity from all the distinguished panelists today. Mehak, can we move to Q&A if that's okay with everybody? Unless, Meenakshi ma'am, you want to add on something at this stage before we move on to Q&A?
Please.
Ma'am, you're on mute.
I said, no, I don't think so. I've already taken far too long. I realize that. Much beyond my time. I'm sorry.
No, that's fine. That's fine.
Yeah.
Mehak, can we?
I'll start. Yeah. Where is the scope for a proposition that original CD or DVD need no certificate, particularly in view words printout DVD in section 65B41? The question is asked by Sai Prasad Vaidya.
No, sorry, 1 second. You have that, yeah. They're saying, where is the scope of proposition that the original CD or DVD need certificate? Meenakshi ma'am, you want to take that?
The question, the court doesn't talk about original CD or DVD in the judgment, but that original CD or DVD issue came up in the judgment, the previous judgment of P. Anwar. As I said, that at the time when the election dispute came, that was the CD that was being played to the masses. So the court said that if that had been produced, that a CD, not a copy thereof, that would have formed a primary evidence. That is the context in which the original CD or VCD is being talked about. I hope that answers the question.
Yeah, absolutely.
Yeah.
The next question. Next question. I think what was the reason behind not furnishing the certificate?
No, I think this is Mr. Tanvir Verma. I'll request you to read the judgment, Mr. Verma. I think there were various reasons behind why the returning officer didn't submit the certificate. Then I think there's a complaint made to Chief Election Commissioner, even that didn't yield anything. So if you read the judgment, you'll come to know there were various circumstances, as ma'am had earlier explained. Thank you for asking that question.
Next question is by Nilanjan Sinha. How will we address the requirement of filing of original documents be dispensed with in civil matter? For example, when document is not in electronic form, like sale deed or mortgage deed, unless documents are just a minute.
Sorry, ma'am.
Unless documents are digitalized, such provisions are impediments to transition to digital world. Did you all get the question, or should I repeat again?
I think we got it, and I can see Meenakshi ma'am smiling around this question. Ma'am, was there a requirement of distinguishing between civil and criminal? And I think there will be a host of questions. Just need your views. I mean, I wouldn't say there would be any complaint.
I think so far as civil and criminal is concerned, I think the only test for criminal was to protect the right of the accused. I don't think beyond that there was anything else extra that was said there. But yes, what the gentleman's talking about is that once you digitize the records, let's say the property ownership record, and then it comes down to the production of a digital document, if suppose it's sought to be produced, etc. But I don't think we really will get into that, because you will always have right to get a certified copy. So you can actually always produce the document itself with the certified copies, etc. I think this is going to lie in terms of an evidence which is going to be purely electronic or digital. So I think there is an overlap somewhere. I don't know if somebody else has a different take on that question.
Apurva, you want to look at Nilanjan Sinha's question? on the sale date. See, you see what has happened is, I must explain here. You see, insofar as immovable properties are concerned, I think they're currently out of the purview of affixing electronic signature. So you're absolutely right, ma'am. I think insofar as immovable properties are concerned, Indian law today does not recognize
Yes.
it as electronic record or electronic evidence. So I think, Mr. Sinha, you will have to wait for mortgages and sale deeds to be electronically proved in any courts. Yeah, Mehak, we can move to the next.
Yeah. Yeah. So again, question by Nilanjan Sinha. It's on the chat box. What is the panel's view on video KYC, e-commerce, and digital marketing privacy? There seems to be an inherent conflict. European Union and US seems to have different positions. What's the panel's view on this conflict? And is there a conflict?
Yeah, Apurva?
Yeah, so I mean, well, there's no actual conflict. I mean, firstly, at the moment, the Indian Personal Data Protection Bill is not come into effect. So we are basically governed by the data protection rules under the ITF. The European GDPR very clearly says that for certain legitimate purposes, you can access private data of individuals. They have considered marketing for valid purposes within those legitimate purpose definitions. So as you rightly said, the GDPR does allow marketing and access of personal data under it. The draft personal data protection bill in India currently does not allow it. You need to seek consent, which in my personal opinion is the right way to go. I don't see any conflict in it. If you are going to access my data, I need to give my consent to it. That's my humble submission. So while there is a difference between the two regulations, we'll actually have to see when the personal data protection bill is actually converted into an act as to how the Indian law provides that. So as I'll just raise one small point on a comment that, you had said in terms of the Supreme Court being sort of some people not being in favor of the judgment. In my humble submission, it's the Supreme Court that has actually clarified a lot of regulations or a lot of aspects with respect to the information technology, even data protection. It's the Supreme Court which in the Puttaswamy judgment said we need to have a personal data protection bill, and it's the Supreme Court right now. So I think the judiciary actually has been one step ahead of the legislators when it comes to sort of simplifying some of these provisions in terms of information and technology. Just small one on that.
Yeah, thanks. Apurva, just kind of mange more. I think people are going to ask for something more always from every Supreme Court judgment that comes in. Thank you very much.
Yeah. So next question is from Anukrit Bhargava. Has the court hinted at all at the data retention period that telecom operators are required to comply with in respect of criminal proceedings? Should I repeat again now?
No, there is no period that's mentioned.
No, there is no period. I agree with you.
There's no period that is mentioned, if I'm not mistaken.
You're right. I think there is no period.
There is no period that's mentioned.
It just says that there is a move to bring out new legislation in terms of retention period for the data.
Sorry, just a small thing. There's no period mentioned. The court in the judgment has referred to the license agreement. Correct. And said that there's a 1 year period in which for internet service providers, but no specific period in terms of data retention that has been mentioned. And what has been mentioned, as rightly pointed out by Ma'am and Suhag, that regulations need to be looked at and modified in that respect.
Thank you, Apurva.
So next question is from Jaideep Khattar. Question is for Meenakshi ma'am. Do you think it's high time that India has evidence-specific law? For example, the same threshold can't apply to prove an email that applies for proving a video recording or an audio clip.
Can you repeat that again? I didn't capture it clearly.
Yeah. Do you think it's high time that India should have evidence-specific law? For example, the same threshold can't apply to prove an email that applies for proving a video recording or an audio clip. Moreover, it is not the need of the hour for providing different rules for providing evidence in civil as well as criminal law.
See, there is one Evidence Act, and that applies to both civil and criminal. So I think I would agree that that has to be always that way. But yes, where it comes to this particular nature of evidence, I will be completely at one with what Justice Ramasubramanian has said, that there is an immense need to amend this law, bring it in line with what has been settled internationally. There are jurisdictions which have taken very similar, and they are working with that. And the UK debate speaks about what New Zealand has done, what Australia has done. And Canada has a very, very advanced, a very good law in that sense. So we must look at those legislations, bring ourselves up to date. Even in 2000, we took a legislation which was outdated. So there is the need of the hour is today to actually amend our legislation and bring it in line for this particular form of, evidence that has to come.
Ma'am, if I may just add one thing.
Please.
I think, while there is a comparison done here with respect to English law, law in Canada, law in the US, I think a major portion of globally benchmarked, data-related evidence and laws are missed out. India is not a signatory to Budapest Convention. That's sad. The second part is, if you look at EU, and I think EU came out with a manual in terms of electronic evidence, as late as March of 2020, which has been published in June 2020. I think my request is that everybody in the audience should read that manual, which talks about what is electronic evidence, how it has to be gathered. And I think, like the European GDPR that we talk about, the electronic data gathering and the EU regulations and the manuals are actually benchmarked at global's best currently available. That's my personal view, but I would say, rather than looking at US and Canada and England, I think we should look at EU or add EU to that list at least.
If I may add to that, Suhas, EU is also, the guidelines of EU are further tempered because they have a very strong European Court of Human Rights, and which has taken a large number of decisions on the electronic data gathering, also for criminal matters, eavesdropping, taping, recording of evidence. So I think that's actually the best form that protects the rights and yet puts in the method of the guidelines as to how the evidence has to be recorded. Because their European Court of Human Rights has been very strong on the electronic evidence and other things.
Absolutely, I agree with you. Sorry, Meg, please go ahead.
Yeah, thank you, ma'am. Thank you, sir. Our next question is by Salil Date. Can a user provide a 65B certificate for himself for his own records on laptop? Especially if he also happens to be a witness, or it should be obtained from an IT official of a company.
Hey, Salil, thanks for asking that question. I'm going to request Meenakshi ma'am. This is a very peculiar situation, and I knew this was coming.
See, if it's your laptop and you are the complainant or you are the plaintiff or whatever, and you are producing that particular evidence before the court from your own machine, your own computer or whatever, you can give the certificate. You can actually even step into the witness box and prove your thing. You don't have to give a certificate at all in that event. But I guess that since certificate has been held to be a gateway entry on an admissibility, if you gave your own certificate, I don't see the difference there than entering into a witness box or giving your own certificate, because the compliance for 65B4 is complete.
Yeah, I think you put it very good. I think it's an entry. It's a kind of a gateway for you to enter into. Thereafter, the admissibility and everything will come.
Yes.
Yeah, sure. Meg?
Yes. Next question is from Tanveer Verma. Please shed some light on how to furnish electronic evidence in
Writ petition.
Writ petition, say an email exchange with the authority.
Yeah, anybody? Apurva, you want to take that?
No, I think it would be better. I mean, people who actually deal with it answer that. I don't think I would be the right person, whether Bansuri or ma'am.
Yeah. Basuri, you want to try that?
Ma'am, you're on mute. Masuri, ma'am.
Yes, my apologies. Sorry, it was please shed some light on the furnishing of electronic evidence in writs.
Say an email exchange with the authority, with the regulatory authority.
There is no
I
principle.
think you have to usually comply with all the regulations which would be required in the Evidence Act, which means that you will require the certificate, especially in light of this judgment. You will have to come in and you will have to give the certificate under 65 B subsection 4.
No, I think it's a very, you see, I would beg to differ there slightly, because I think, you see, what's happening today in India, when we look at compliances, for example, in the regulatory space today, 65% of the compliances are online. If you go on MCA website today, the MCA website allows you all electronic filing. Your income tax are electronically filed. So when you talk about regulatory filing, there are certain presumptions built into respective statute with respect to the evidence itself. Now you have to first look at whether that presumption or that document or the record qualifies for the presumption there, then you may not be required to prove anything. Yeah, ma'am.
In a writ jurisdiction, you perhaps may not require a certificate at all, because the requirement to prove a document is in a civil suit or in a criminal trial, etc. Writ jurisdiction is entirely different. The court will never get into a matter which is disputed evidence at all in a writ jurisdiction. So that strict test of an evidence, as would apply to a civil suit or to a criminal trial, never does apply to a writ jurisdiction. So if you file a certificate, it's another thing, you may file so, but that strict level of evidence that comes in a writ jurisdiction is never ever so. That applies only to a suit or to original proceeding, but never to a writ jurisdiction in that sense.
Thank you. Thank you very much for that clarification, ma'am. That's why we need seasoned lawyers who can answer these questions on the spot.
Thank you, ma'am. So next question.
While I know we've overshot the time, so ma'am, may I request you for, and we will take some of the questions subsequently, but I wanted to request Meenakshi ma'am for actually, summing up and giving us some guidance with respect to what do we do in future.
Tall order, Suhas. I think the way forward is, while the judgment is good for the moment, it is good for the moment, I will say, but it is not good in terms of it. It cannot, because the judgment only takes the law as it stands on the statute book today. And the statute book says, notwithstanding anything else, so the judges have interpreted the provision and said that you have to cross that goalpost. But there is an imminent need for an amendment. We may supply that lacuna through this judgment for a small period of time, but given the multifold use of electronic documents, materials, videos, whatever form, in commercial transactions and otherwise, I do not think that we will be able to survive only with this particular guidelines for too long before we have issues of multifarious things which will come up before the court sooner or later. And therefore, the sooner we look at the amendments, the better it is for us, is what I would say the way forward. I say it's only a stopgap for the time being.
Thank you very much.
Hello. Suhas, I want to add something. Legacies is playing a very big role in IT and lawyering. Means it's a very good fusion in India. So this fusion can play a very good role in drafting a law. We all need to contribute to the government of India. Incidentally, both the ministers are very good, and we need to, and I will play that role. So legacies has to play a good role for drafting a good law. Because this judgment is going to impact on the present law, which will delay the trials at every level. Since the entire onus is on judge now, everybody will move an application with the judge, and the certificate has to be given. So that has been upheld now. Requirement has been upheld. Even in REIT now, if I rely on some document obtained under RTI or in PIL, if I am relying upon some RTI paper, somebody will come and say, where is the certificate? So this law need to be amended. This is the need of our, and I request legacies to play a big fusion role. God bless you.
Thank you, sir. I think in lockdown, I was trying to learn a computer language, which is our language called R.
Very good.
Now you're telling me to learn to draft the law. I mean, I'm not sure whether I'm capable of doing that, but thank you very much.
No, I was very happy to see the word lawyering.
No, thank you.
Congratulations. Must support.
Thank you.
Thank you, ma'am. Thank you, Sharma ji. Thank you, Basura ji, Apurva, our champ. Thank you very much.
Thank you very much. I think what I'm going to request, Mehak, is that we will circulate the balance questions and we will reach out to the audience. I think
Sure.
It's been 1.5 hours, an exciting 90 minutes that on a Saturday evening, I must thank you all and also thank all the audience. There are still about 70 people who are listening to us on a Saturday evening at 7 p.m. I think this topic deserves nothing less than this. And Meenakshi ma'am, it's our honor to kind of hear you.
I enjoyed it as much.
Thank you very much, ma'am.
Thanks
a lot.
Thank you, everyone.
Ramesh ji, thank you very much.
Thank you, Suhas.
I wish we had more time, and we will kind of try and kind of see whether we can do this differently. Mea culpa for not giving enough time for everybody.
Thank you.
Thank you very much. Thanks a lot.
Thank you.
Thank you, everyone.
Very good.
Thank you, everybody.